has been trying to do over the last year or so is put out a short summary of some recent commission decisions, and by recent we mean decisions that were probably written about 6 or 8 months before. We're going to try to do that every month, and we're going to try to have those summaries out to you every month to the members. So the cases we're going to talk about today are the cases that were reported in the WICLA newsletter in May. So we're already a couple of months behind. We just can't keep up with all of this new case law and decisions that the Commission is writing. So we have to try and keep up, but we're already 2 months behind. So what I've given you here in your written materials are a few slides of some of the cases that I've selected to speak about, which are, in my opinion, the more fun cases to talk about. They're accident cases primarily, and so there's always a little bit of a factual situation or dispute or some kind of twist or turn in those cases that make them fun to talk about. I'm sure they weren't that fun for the lawyers to try, but they're fun to talk about after the fact. The other part of your written materials, of course, is the written summaries that went around to you by email. So these are all the cases that were reported during that reporting period back in May, or about 60 days or so ago. So any questions about that? Everybody getting those newsletters? Everybody getting these case summaries? Right? We've actually been getting, I think, pretty good feedback about those. I think the members like that. If you have any suggestions about how to improve that service to members, we're all ears here at WICLA. We're happy to receive those kinds of suggestions anytime. So if you have a suggestion for improvement about these things, just let us know. Any discussion about that? Comments, concerns, questions? Okay, great. So what we're going to do is, as I said, talk about a few of the accident cases that were reported in this particular newsletter. But before we do so, I do want to draw your attention to the written summaries, because they're the first 2 cases that are reported here in the written summaries we're not going to really talk about, but I think are important for us to know about. The first one is actually a federal district court case called Daly versus Jones Motor, where plaintiffs filed some cases over in the federal court arguing that there were some violations of some federal laws and some other laws regarding misclassification of employees under the workers' compensation insurance policies for those particular employers. And what the court said in that case was that the Illinois Workers' Compensation Commission has the jurisdiction, exclusive jurisdiction, to decide those issues of employer-employee relationships. So it's an interesting case in which the federal court is telling us, Workers' Compensation Commission lawyers and arbitrators and commissioners, that those kinds of issues are to be decided here at the Workers' Compensation Commission and not in other courts like the federal court or state court. So it's an important case if you're making that kind of an argument in a case outside of the Workers' Compensation Commission. Here's at least one federal court saying that the Workers' Compensation Commission has the exclusive jurisdiction to decide those kinds of issues. The second case, which is a Rule 23, which I know we're not supposed to cite as precedent or talk about in terms of how it might affect other decisions, but I think it's an interesting case to talk about anyway, is this Chavez case. And it's interesting to talk about because it has to do with occupational disease, okay, and what types or levels of exposure you have to prove in order to prove an occupational disease case. In this case, the petitioner was a mechanic who was claiming that due to gasoline fumes and oil fumes at the job that he had developed a certain kind of cancer. And the testimony was that the treating doctor said I know he was exposed to these kinds of things because he was a mechanic and exposed to gasoline, and therefore I draw a causal connection between the exposure and the cancer, at least some causal connection between the exposure and the cancer. And the respondent's expert, Dr. Conover, who you may have seen around, you may have seen around before in other cases or used in other cases, said, look, we don't know the exact levels of exposure. We don't know how high those levels were, parts per million or whatever, that kind of thing. And therefore, there is no causal connection between the exposure and the cancer. And the appellate court bought that argument, right? The appellate court said, yes, that it's appropriate for an expert to say that, and if the commission bases its decision on an expert saying there's no causal connection because we don't know exactly what the exposure levels were, then that's fine. That's not contrary to the manifest weight of the evidence. The petitioner in this case, though, pointed out a whole line of cases that, we talked about actually here before, that say that you don't have to prove a certain level of exposure, right? If you prove exposure, right, and that exposure is a causative factor in the cancer, then presumably you should win. And the appellate court said, that's great. There is no minimum level that you have to prove, but it doesn't hurt to do that, right? And the commission can make factual determinations and credibility determinations and give weight to experts who say that cannot be done, right? That you can't measure the exposure directly. There's a dissent in this Rule 23, which is a great dissent, in my opinion, by Justice Holdridge, who says, look, the case law says if you prove an exposure and you prove any exposure, and you prove that exposure is a causative factor in the condition, then you've sustained burden of proof under the Workers' Compensation Act. So Justice Holdridge is dissenting based on that line of cases. All right? So I did want to point out those two cases because I think they involve some important issues for us, this idea of employer-to-employer relationship and also this idea of occupational disease and exposure levels. Any questions or comments or concerns about that? Yeah, Tom.
Was there any discussion about whether it would have been possible for the petitioner to prove what the level of exposure was, or how great a degree of toxic material he was exposed to?
I don't recall that there was. I don't recall specifically. Certainly, if there was that, it wasn't highlighted in any particular way. And I think part of the reason behind that was that, maybe the petitioner realized, how am I ever going to do this, right? Unless I can get back into that garage or whatever with a gauge or, I don't even know what it would be, right? Some kind of measuring device that measures, parts per billion or something, for the particular substance that you're exposed to. I don't know how you would do that. I suppose maybe OSHA records or reports, things like that. But absent those kinds of things, I don't even know how you would do it. Maybe expert testimony, I suppose, have an expert say, look, in a gallon of gas, it evaporates, this quickly and it throws off this many parts per billion per hour or something, I don't know how you do it otherwise. And at the end of the day, the respondent, I'm sure, is probably going to argue that that's still just all speculation, anyway, that it's, not hard and fast evidence. All right, anything else about these two? Okay, good. So let's get into the cases that were decided by the commission. And these first two cases that we're going to talk about are accident cases. And so, like we always try to do, we're going to try to identify, which of the two prongs, or maybe both of the prongs, are involved here. And by the prongs, I mean in the course of an arising out, right? The two prongs of compensability in workers' compensation, right? So, the Cody Harris case versus United Parcel Service involves, I think, both of the prongs, the in the course of prong and the arising out of prong. So let's take a few minutes to talk about it. So in this particular case, the Workers' Compensation Commission affirmed and adopted with a dissent by one of the commissioners the arbitrator's award of benefits under Section 19B. These benefits were awarded to an employee who performed the job of bulk line collection roller. And on this particular day, she was involved in a one-vehicle collision. She was driving something called a PITO, which is apparently like a little tug kind of truck. She was involved in a one-vehicle collision before her work hours actually started on that day, after she had gone to the company cafeteria to get an order of fries to bring back to her workstation. But on the way to get the order of fries and on the way back before she crashed the vehicle, right, she testified, and it was supported by some of the testimony from the respondents' witnesses, that what she was actually doing is kind of on the drive over to the cafeteria, and after she got her fries on the way back, she was looking for bins that were scattered around the premises that she would then take back to her workstation and use at her workstation, right? So you get the picture, right? She says that I'm going to get my fries before work starts. You know, I'm on the premises. My work is supposed to start in like half an hour or whatever. As I'm going to get my fries, I'm looking around for these bins. If I see a bin, I toss it on the back of the tug truck or whatever, and I get my fries, and on the way back, I'm still looking for some bins, and bang, I crash the vehicle, okay? At the time that Ms. Harris crashed the vehicle, she did not have the appropriate license to be driving that vehicle. Her license or certification or whatever it is to be driving that vehicle had expired or had been canceled or whatever, but it's clear that under the circumstances, she did not have the proper license, right? So, you can see the respondent's defenses already, right? Hey, it's before working hours begin, right? She's really going to get an order of fries, right? She's not really doing her job, right? She doesn't even have the license to drive that vehicle. And so you can see all the issues, right? You know, in the course of, right, arising out of, violation of the safety rule, right? All of those kinds of things, right? So let's look at how the arbitrator analyzed it. Of course, the commission affirmed and adopted the arbitrator's decision. So what the commission said, or the arbitrator says, first of all, is that even though she's not working yet, you know, her work hours don't start until about a half an hour later, she's what they call an early arrival on that day. So she's the first one who's supposed to show up on that day, and she's supposed to set up the job for everybody else. So what the arbitrator said was that even though she wasn't punched in or quote-unquote working at the time, she was doing work that would benefit the employer collecting these bins because she was the one who was assigned to set up the job on that day. So that's the first part of it, right? She's in the course of, right, because she is doing something for the benefit of the employer. By the way, the employer's witnesses said that that had been done before, right? They knew that people would show up early and collect these bins and get everything set up before they actually started working on that day. So she's in the course of it, okay? She wasn't really working in her job as a collection roller when she got into the taxi. She was driving the PITO tug truck, right? But the arbitrator said that the employer derived some benefit from her doing that, and therefore she's in the course of her employment at the time. The respondent brings up the idea that Ms. Harris did not have the valid license to drive this tug truck. And they phrase that in terms of the violation of the safety rule, right? So the employer said, look, she violates a safety rule when she's driving one of these trucks as an unlicensed driver, and therefore she is not entitled to benefits. And, you know, there's some debate among lawyers about whether violation of a safety rule is an in the course of case, like if you violate a safety rule, you take yourself out of the course of the employment, right? Or it's a violation of a safety rule and arising out of, because you're violating a safety rule, it no longer arises out. I guess it doesn't really much matter, but generally speaking, a violation of a safety rule has not been used to defeat claims, at least the courts have said that, right? Especially if you're doing your job at the time you're violating the safety rule, right? If you're doing your job at the time you're violating the safety rule, the courts have traditionally said that those kinds of things are compensable anyway because you're doing your job, albeit in violation of the safety rule, you're still doing your job. In this particular case, the petitioner also added to the mix of proof that the employer seems to have acquiesced to this violation of the safety rule on previous occasions, right? There was some evidence, some credible evidence, that the employer knew that maybe there were some employees who did not have the proper license to drive this particular kind of truck, but kind of looked the other way when those employees were doing that work, okay? There was at least some evidence in that regard. So this idea of even if you violated a safety rule, if the employer has somehow acquiesced in the violation of the safety rule, that somehow cures the violation of the safety rule if it needed curing in the first place, right? So what about the fries, right? What about going to get the fries, right? The respondent brings that up too, right? Like going to get fries, what's that all about, right? And of course, the arbitrator responds by saying personal comfort factor, right? You're on your employer's premises. It's the cafeteria on your employer's premises. Fries are really comforting, right? And so, it's the personal comfort doctrine. At least fries are comforting to me. I don't know about you, but it's the personal comfort doctrine, right? So, doing something like that, even though it's not technically working, right? It's within the personal comfort doctrine, and therefore it's still in the course of and even still arising out. Okay? So, any questions, comments, concerns about that one? Yeah, Mark.
I don't have a question, and I actually agree with the outcome, but I want to point out how unworkable the safety rule concept is. Because if you look at the safety rule cases, what the courts have held is that if you are engaged in a prohibited act, then it's not, and you're injured while engaged in a prohibited act, it's non-compensable. But if you're injured while engaged in a permissible act, but doing it in a prohibited manner, then it is compensable. So if you apply that to the facts of this case, is she doing a prohibited act, in driving without a license, or is she doing a permissible act, namely driving, but in a prohibited manner, namely without a license?
So Mark is drawing this distinction between permissible and prohibited, right? And I think the petitioner maybe tried to cover it both ways, right? Look, it's permissible. I mean, I was doing it and it was no big deal, right? But even if it were prohibited, because the employer acquiesced, maybe, right, in the violation of the safety rule, maybe it's no longer that prohibited, right? Maybe it's prohibited by law, but not actually prohibited by the employer who kind of knows that that's going on. So it was a really good way to prove the case, right? To not just rely on the fact that, oh yeah, I can violate a safety rule as long as I'm doing a part of my job, but also this idea and the employer acquiesced in the violation of the safety rule, right? Because otherwise you get these cases that we talked about here. I don't remember the name of the case, but the masonry guy who falls off the scaffold, right? Because he doesn't close the guard door on the scaffold, right? And the testimony there from the respondent's supervisor is right before the guy falls off the scaffold, he yells out, "Make sure you close that, make sure you got that guard, gate closed," or whatever, right? So you could sometimes get, situations like that. Or you get, safety rule number 1, which is don't get hurt at work, right? Violation of safety
rule number 1 is don't report it.
So So I think that's where some of these issues come up, right? Okay, good. Anything else? Any other questions, concerns about that one? Comments? Okay, good. And by the way, I know that there are people in this room who know these cases better than I do because you tried them, okay? So please, if I'm saying something crazy, please. All right, so let's talk about the Christina Herring versus Kindred Hospital. And this is a great case, again, because it talks about the kinds of risks involved with employment, right? And again, not to beat a dead horse, but I'm going to beat a dead horse, right? The 3 risks involved when we're talking about analyzing a workers' compensation, right? Personal risk, right? Never compensable, except under very, very extraordinary circumstances. Might as well say never compensable, right? Employment risk, always compensable, right? Neutral risk, maybe compensable, maybe not compensable, okay? So let's talk about the Christina Herring case in the framework of that kind of analysis. So in this particular case, once again, the commission affirms and adopts on a 2-to-1 decision an arbitrator's award of benefits to a nurse. So the nurse wins this case. Here's what the allegation of injury is, right? She's squatting down under a patient's bed, so the word squatting is used. She's squatting down under a patient's bed to empty out some type of collection bag or catheter bag into some type of graduated cylinder so they can measure the fluid, right? And so as she's getting back up with the bag and the cylinder, making sure to not spill, right? She feels pop in her back, right? So the history is squatting at work, getting up from a squat, pop in the back, all right? And Nurse Herring says, I'm covered under workers' comp, right? When that happens to me, right? I'm at work, I'm doing what I'm supposed to be doing, and I hurt my back at work. Well, the employer says, no way, right? Because squatting and standing up from squatting is a common, everyday, mundane activity. And it's not associated with the employment, right? So it's not an employment risk, right? And if it's a neutral risk, it's the kind of neutral risk that is not covered under workers' compensation. So let's look at how she wins the case, right? So she tries the case, and the first argument that the nurse makes is that this is an employment risk, right? The risk of squatting and getting up is a risk distinctly associated with the employment. And she makes the argument, and the arbitrator and commission buy the argument, that what she's doing is a very specific kind of maneuver, right? She's got this empty bag in one hand. She's got this open container, the measuring cup or whatever it is, in the other hand, right? And she doesn't want to spill, right? So she's, very carefully and maybe even awkwardly, getting up. And that's the argument on which the arbitrator awards benefits and the commission affirms, right? That particular maneuver for a nurse, right, is distinctly associated with the employment. Therefore, it's an employment risk, and therefore, it's a risk that is covered under workers' compensation, right? So she wins her case. But just for good measure, right, belts and suspenders, as Mark always says, right? Belts and suspenders, right? You get to an analysis of this case where it's a neutral risk analysis, right? So the nurse says, look, even if that were a neutral risk, right, even if it were a neutral risk, which it isn't, because I've already proven that it's associated with the employment, but even if it were a neutral risk, okay, it is quantitatively and qualitatively different from the types of risks that the general public faces, and therefore is covered. You know, the quantitative part is pretty easy, right? I do that many, many, many times a day. Right? As a nurse, that's part of my job. I do that many, many times a day. The quantitative part is easy. The qualitative part, I suppose it has to do with I didn't want to spill and, you know, having things in both hands, so I couldn't catch my balance. But as we've talked about before, if you're saying that that is a neutral risk, that it's qualitatively the same as an employment risk, then it's an employment risk, right? So, which she had already proved. So, interestingly enough, in this case, what the commission says is it's both, right? It's a risk associated with the employment, but even if it isn't, it's a neutral risk that's covered because it's quantitatively and qualitatively different from a risk that the general public faces. So it gets us back into this situation that we've talked a lot about in recent months, right? This idea of common everyday activity, right? Just because it's a common everyday activity doesn't mean that it cannot be associated with the employment, right? Or vice versa, I suppose. But the fact of the matter is that just saying, but that's common. You have to do that every day. You do that outside of work. You don't necessarily have to practice doing that, or be, you know, there's nothing unusual about that, right? That's not enough to take a case out of the compensability of the Workers' Compensation Act. You've got to analyze whether it is somehow associated with the employment, even if it's a common everyday activity. All right? Any discussion about that one? Any questions, concerns? Okay. So let's look at the Gertrude Burkhead versus Norfolk case. So here's a denial of benefits. Here's a case where the commission affirms and adopts the arbitrator's denial of benefits. It's a slip and fall case, right? So we talk a lot about slip and fall cases. Well, here's another one for us to talk about. So in this particular case, the petitioner is in the bathroom at work, you know, personal comfort, right? Just like we talked about earlier, so there's no issue about her being in the course of being in the bathroom at work. It's covered under personal comfort. The question is arising out in this case, right? What made her fall? Her testimony, especially at the hearing before the arbitrator, is, quote, no question, close quote, that I slipped on water in that bathroom, water on the floor in the bathroom. No question that I did. Well, apparently there is a question about whether she slipped on water in the bathroom, because the employer in this case did a very quick and a very comprehensive investigation right after this incident occurred. It's Northrop Grumman, so you can imagine the security there, right? I mean, somebody reports that somebody fell in the bathroom. It's like, you know, SEAL Team 6 comes in, right, to do the investigation. That's pretty much what happened here. They have an investigator on the scene right away. He's taking pictures. He's asking questions. He's getting the petitioner off to the hospital because her ankle is fractured such that it's going 90 degrees, you know, from out from the leg, right? I shouldn't have, but so he's all over this, right? Their investigator is all over this right from the very beginning. And apparently there is some question about whether there was actually any water on that floor. The petitioner says, no question, I slipped on water, and the investigator said no water whatsoever. They take a recorded statement from the petitioner within a few days of the incident, less than a week later. She says, of course, like most of my petitioner clients do anyway, right? I don't know. What do I know? You know, all I knew is that my ankle was sticking 90 degrees out from my leg, or, you know, right? I don't know what caused me to fall, right? So those are the disputed facts of the case. And under those circumstances, what the arbitrator does is say, look, I believe that I believe the investigator, right? I believe the investigator. There was no water, that there was no substance on that floor that caused the petitioner to fall. And since the petitioner was so locked into that version, right, no question that I slipped on water, right? The arbitrator said, I don't believe her, even though the arbitrator says, look, she seems like a very nice woman. She's worked for this company for 50 years or something, or some crazy thing, right? She seems nice, but I don't believe that she slipped on water. And when she says, I don't know what caused me to slip, then there's no arising out of component, right? Because there was no evidence about hurrying to get back to the, to her desk or carrying some work-related things or anything like that, right? It was all about the water on the floor. No question it was about the water on the floor. All right, so under those circumstances, the petitioner does not prevail. So, we've all had these situations, right, where our clients, on one side or the other, right, get locked into a version of the events. And it might even be because it's true, I don't know, but sometimes the lawyers like to give our clients a little wiggle room, right? Are you sure of that, And sometimes it works out and sometimes it doesn't. There's a second important issue here, right? There's a second important issue which has to do with credit for missing a Section 12 evaluation, okay? So in this particular case, the petitioner missed a Section 12 evaluation, right? She claimed it was because she never had noticed, but for whatever reason, she missed a Section 12 evaluation. The respondent claimed a credit for the no-show fee on the Section 12 evaluation. And the arbitrator decides, in this case, that there is no such credit, that the Act does not in any way authorize the respondent to take a credit for a no-show fee to the IME, right? That there's no provision in the Act that allows that, there's no rule that allows that, there's nothing even implied in the Act that would allow the respondent to get a credit back for a no-show fee for a Section 12 evaluation, okay? So if ever you get that request from a respondent, you can cite the Burkhead case because as far as I can tell, this is now a final decision of the commission that says that there's no credit for a no-show fee for a Section 12 evaluation. Now the arbitrator says, look, there is a penalty for no-show, right? The penalty for no-show is suspension or termination of benefits, right? Right? That's the penalty. But Ms. Burke has lost her case, right? So there were no benefits to suspend or terminate because of the no-show. So the penalty is suspension or termination benefits, not somehow being refunded a no-show fee. All right? Any questions, concerns about that one? Okay, good.
David, was there any mention in the case itself that they had evidence that the petitioner received a travel check and cashed it when they asked for the credit for the missed appointment?
I honestly don't remember, Rich, but the decision will be posted online later on, so you can look it up. The arbitrator, there was a long analysis of this part of the case. So it probably is in there, I'm just not remembering it off the top of my head, but it's like a 1 or 2 page analysis of this particular issue, so it's really spot on. All right, anything else? Any other? Yeah.
So, if I understand the whole thing here correctly, you're better off saying, I don't know why I fell, as opposed to being wrong about what you thought you fell. Unexplained falls are compensable.
Well, from your lips to God's ears, right? Or arbitrator to commissioner's ears,
But it depends on who the fact finder
well,
is.
yeah,
I'm still waiting for one.
Right, so Mark, look, I agree with you that unexplained, but who cares, agree with you that unexplained faults are compensable, right? Because you've eliminated the personal risk, right? If you said you don't have to, and by the way, Ms. Burkhead did that, right? She was careful to say that, right? Because there was some discussion in this case about she was being on a fast. She was on a fast for a few days before she fell, And was she dehydrated, or was she kind of woozy because she was only taking in 500 calories a day? Was it that kind of thing? And that was all debunked in the case, right? She said there was no personal, and proved it, there was no personal reason for me to fall. So, but she did lock into this, and the arbitrator puts it in quotes, just like I did. No question that I slipped on the water, right? Yes.
And then just to follow up, so in order to, and again, we're still waiting for an unexplained fault to be compensable, but considering what happened here, do we have to have a situation there where the claimant does not know why she fell, but yet there was a work-related risk there?
She fell,
and explained it, and she knows. I mean, it's kind of.
So, I mean, again, if you look at this decision, again, it'll be online, but the history is down the line, right from the very beginning, right? Slip, 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 slip. That's the word she uses from the very beginning, right? There was some question about the incident reports were put into evidence, okay? But the arbitrator made it a point to say I did not rely on the incident reports in making my credibility determinations. I think the incident reports were put into evidence for notice purposes, not for, proof of the truth of the matter asserted in the reports, right? So, but even in those reports, it slipped, right? Slip, 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 right? So, I know it's too simplistic a view, but my view is when you slip at work, right, that's a work-related injury, right? When you slip at work, right? Yes?
Aren't we creeping into the fact that we're going to have to prove negligence? We're going to have to prove, like the case we went last time with the water in the crack as opposed to a hole. I mean, the mental gymnastics these people are going through is incredible. She had a fractured malleolus. You don't get that with the coefficient of friction being 55 because there's no water on the floor. Something was there.
So, Brittany, I couldn't agree with you more, but it was also
it's generational.
It was also my office that had the Dukich case. So what can I tell you? Yeah, Tom.
Was this a factory? Because if it was, factories have grease and oil and silicone sprays and all that kind of stuff that gets on the floor and gets on people's clothes.
I don't know, is anybody aware of this facility, this Northrop Grumman facility? Because they apparently have 20 employee bathrooms. That's how big a facility is. Does anybody know this facility?
Yeah, I was going to say.
Yeah. Aren't they defense contractors? Yeah. So my military buddy over there tells me they're defense contractors.
I think it's an office.
Okay.
I think the factory is in North Carolina.
By the way, the employer said, we clean that bathroom 100 times a day around the bathroom, right? But that bathroom is spotless. There's never a drop of water in that bathroom. Okay? So, all right. So let's talk about the Jose Avalos case versus Caldwell letters. Let's talk about unexplained things, right? So this is an assault case, right? And in this case, once again, the petitioner wins because the commission affirms and adopts the arbitrator's award of benefits, right? So here's the facts of this case, right? Mr. Avalos goes into his boss's office to borrow a tape measure. There's some disagreement about why he was borrowing the tape measure. Was he actually doing work? Was he going out to like fix his own motorcycle or something, right? Whatever. He comes back with the tape measure. As he's walking out of the office, the boss starts snapping pictures of him on the phone, and he's like, hey, what are you doing, right? We take pictures of you. And apparently, for no good reason, the boss comes and pushes him and knocks him down and throws him into the, something, and he gets injured, right? So at the very best, right, we have a work-related dispute, something about the tape measure, or you shouldn't be doing, your own personal stuff on work time or whatever. But at the very least, what we have is an unexplained assault, right? hey, I was just minding my own business, and all of a sudden this guy's attacking me at work. You know, what am I supposed to do about that? So the commission, although it affirms and adopts the arbitrator's decision, added some analysis to the decision. And so when it's posted, take a look at the decision. But the commission goes into a history, a short history, unlike what I'm doing right now, a short history of assault cases, right? And the commission says, you know, there's still these cases on the books, right, from 1946 and 1971, a few, you know, cases that, you know, have a little loss on them, right, that say that unexplained attacks are not compensable, right? So that you have to have this work-related reason for there to be the attack before it can be covered under workers' compensation. But the commission then goes on to say the more recent cases, like Health and Hospitals Governing Board and Rodriguez, right, especially the Rodriguez case, which is a 1983 Supreme Court case, say that unexplained assaults at work are in fact compensable, right? Especially where there's some evidence that the assaulting, you know, the person who is doing the assault, the assaulter, I don't know, the attacker, right, was somehow a little bit goofy, you know, a little, you know, hot-tempered or a little, you know, a little crazy, right? And so, you know, having one of those hot-tempered, hair-trigger kind of employees on the job is just like having a faulty machine, right? When the machine blows up and you get injured, right, that's covered under workers' compensation. When the guy, you know, who's a little wacko, you know, blows up and beats you up, it's the same as like the machine blowing up, and that's covered. So the commission focuses in on those kinds of cases, the Rodriguez case especially, which says that if you can't necessarily explain the reason for the attack, as long as you show that it's not a personal reason, right? So as long as there's no personal reason for that attack to have occurred, and of course, the second prong of those cases is always, and you were not the aggressor, right? You were not the one who provoked the attack or started the attack. As long as those two things are there, not a personal attack, and you didn't provoke it, then that's covered under workers' compensation. Okay? So as the commission says here, the facts clearly show that this wasn't a personal dispute. It was either work-related because of that tape measure, or more likely just one of these kinds of unexplained attacks which are covered under workers' compensation. Okay, so if you're working on an assault case or an attack case, this is a good recent case to kind of remind yourself about what the law is in those cases. All right, any questions or concerns or discussion about that one? Okay. Steve Goodson is a really good case because it reminds us of how the date of manifestation works in a repetitive trauma case. All right. So it's a little complicated, but suffice it to say that in this particular case, what the commission did was pick a date of manifestation that had to do with when the petitioner was told by his treating doctor that he had carpal tunnel syndrome and that there was perhaps a work-related component to his carpal tunnel syndrome. So even though his primary care physician had talked about maybe you got carpal tunnel syndrome earlier than that, the manifestation date was actually later after he saw the specialist. And that's important, of course, and it's important in this case because you've got to be careful about the notice, right? Because if that original date of manifestation is more than 45 days back from the notice, right, you might have a notice problem on your hands, and there was an issue regarding the notice here. But this is a good case to look at the various types of dates that can be picked for a manifestation date and how you can kind of make that date line up with the date of notice, right? There's a notice issue here too, where, maybe Mr. Goodson didn't really, explicitly and emphatically say, and by the way, this is work-related, this happened at work, but the commission says, he was close enough to having said something like that, and there's no show of prejudice against the employer who had plenty of time to look into this and figure it out, okay? So it's a great case to look at for manifestation date and notice in a repetitive trauma situation. Okay? Joseph D. Leonardi versus City of Chicago case is an important case because it's a case where the commission reverses the arbitrator's denial of benefits. So the commission awards benefits in this case because the commission, contrary to what the arbitrator had focused on, decided that the petitioner was a traveling employee, and the risk analysis is different for traveling employees than it is for non-traveling employees. So what the arbitrator, so Mr. D. Leonardi is an employee of the City of Chicago, an inspector or something of some sort, out and about all day long, right? Getting in and out of his car, just look at sites or whatever all day long. One of the times he opens the door, steps on the curb, twists his ankle, right? Nothing wrong with the curb. No, the curb was perfectly fine. And that's what the arbitrator focused on, right? The arbitrator focused on, the arbitrator saw this as a Caterpillar case, right? Remember Caterpillar from way back when, where the guy steps off the curb and says, hey, nothing wrong with the curb, I just stepped off the curb and twisted my ankle, and the Supreme Court said, yeah, too bad, that's not compensable, right? That's basically what the arbitrator looked at this case as, right? You couldn't say there was anything wrong with the curb, you couldn't say that there was dirt or mud or anything on the curb or anything slippery on the curb, therefore not compensable, right? But the commission says no, right? That's not the analysis. The analysis is that Mr. D. Leonardi, just like the petitioner in the knee case, NEE case that we've talked about here before, who was also an employee in the City of Chicago doing the same thing that Mr. D. Leonardi did, which is go from site to site inspecting things. Just like in the knee case, Mr. D. Leonardi was a traveling employee. And a traveling employee is covered under the Workers' Compensation Act when that traveling employee faces the risks of the street, as it's called in some of these cases, right? And curbs, even if they're perfectly fine, perfectly non-defective, curbs are considered to be a risk of the street, and therefore, when you're a traveling employee and you trip on a curb, even though it's perfectly fine, that's covered under workers' compensation, right? So the traveling employee takes that risk analysis that we talked about, right? The personal risk, employment risk, neutral risk, it takes it out of the ballgame, right? Traveling employee, the risk analysis is it reasonably foreseeable to the employer that something like this could happen? And if it is, that's the risk analysis for workers' compensation purposes for a traveling employee. And obviously, somebody who's getting in and out of the car all day long, it's reasonably foreseeable that there's a trip on a curb. Okay? So, any questions about this? Any comments about the traveling employee? Okay, the last case that I wanted to talk about is Juan Mota versus Greco. And the reason why I wanted to talk about Juan Mota versus Greco is because it involves an 8.1B analysis, the 5 factors, the ANA impairment rating. And this is one of those cases where the ANA impairment rating was 0, right? 0. But look at what this injury was, right? It was a really bad injury. It was, depending on how you looked at it, either a displaced or non-displaced fracture of the tibia, which required a rod to be inserted in this guy's leg, right? So a really, from my point of view, a really pretty bad injury, right? 0 impairment rating. 0 impairment rating for that type of injury. So in this particular case, the commission affirms and adopts the arbitrator's award of 45% loss of useful leg, even though there was a 0 impairment rating. And look at the arbitrator's analysis of the impairment rating. And the reason why it's important to look at the arbitrator's analysis is because the arbitrator highlights the idea that even as objective as these impairment raters want to make this type of impairment rating be, right, there is always some subjectivity involved, even on the rater's part, right? For example, what box do you put it in, right? In this particular box, the rater put it in the non-display, in this particular case, the rater put the injury into the non-displaced fracture box, right? And the arbitrator said, yeah, well, I don't think it's a non-displaced fracture. I mean, they had to put a rod in the guy's leg. It's a displaced fracture, and if you put it in the displaced fracture box, then the range of impairment ratings is much higher than zero. Anything's higher than zero, right? But I mean, from 14 to 100% if you put it in the right box. So, because the arbitrator felt that the impairment rater had put the impairment rating into the wrong box, and we talked about the boxes before, we looked at the charts and the matrix and all of that, right? Because the arbitrator felt like the impairment rater had put the injury into the wrong box, the arbitrator says, I give that impairment rating very little weight, and therefore I'm allowed to write a 45% loss of use of the leg, even though there's a zero impairment. Okay, so I just wanted to highlight this case because from both sides, whether you're on the respondent side and you want to say, that's the best impairment rating I've ever seen. It was done exactly correctly. It nails it, right? Or if you're on the petition side and you want to say, yeah, that's a BS impairment rating. There's always at least some subjectivity involved in those impairment ratings, even though they report to these objective kinds of tests, right? All right, any questions, any concerns, any comments? All right, thanks everybody for coming.
Insurance companies don't want to do it.